All right. Judge, may I open court?
Yes, please.
Thank you, Judge. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 20-3010, United States of America versus Shan Shi appellants. Mr. Darrington for the appellant, Ms. Ralston for the appellee.
Good morning, Mr. Darrington. We will hear from you.
Thank you. Good morning, Your Honor, and may it please the court. Mike Darrington on behalf of defendant appellant Dr. Shan Shi. Your Honors, the insufficiency of the evidence in this case is nothing short of staggering. Dr. Shi was convicted of one count of conspiracy to steal trade secrets, even though the government's star cooperating witness, Qui Bo, whom the government described as Dr. Shi's right-hand man, and who admitted during trial that he was highly motivated to testify against Dr. Shi, flatly denied that Dr. Shi was part of any agreement to steal or use any information from Trelleborg, the victim company.
Counsel, the question that was put to him didn't say steal or use, it said steal, right?
Your Honor, you're correct. The question did say steal, and the government makes much of that point by seeming to argue that Mr. Bo parsed the language of the actus reus within the statute and silently differentiated between the act of stealing and the act of using stolen information. So while Your Honor is correct that the word used was steal, we think that it's fairly clear that Bo was testifying that there was nothing, there was no information stolen, no agreement to steal information, and no agreement to use stolen information in any way.
How is that consistent with our obligation to consider the evidence in the light most favorable to the government and give the government the benefit of all inferences? You want the benefit of that inference here, right?
Respectfully, no, Your Honor. We think that that inference would actually be unreasonable for the jury to have concluded that Bo silently parsed the statute and quietly thought there might be an agreement to do something with stolen information, but not to steal information. And in any event, the burden here is on the government, and the government chose not to even redirect Bo, its star witness, who had just denied that there had been an agreement to steal trade secrets from Trelleborg. So we think that speaks volumes. The government, rather than trying to risking drawing attention to this statement that entirely exculpates Dr. Shi, chose to just let it be. So we think because it's the government's burden to prove that there was a conspiracy and an agreement beyond a reasonable doubt, the fact that the star witness denied that there was an agreement to steal trade secrets from Trelleborg constitutes enough that there couldn't be a reasonable inference. He meant something else, that there was stolen information in play here.
Dr. Shi met with a company called Cuming to discuss with them the possibility of some sort of a joint venture. And the evidence was that during those negotiations and discussions, Shi was told that Cuming's technology was proprietary and they would not disclose specifics of their formulations for these macrospheres. Isn't that correct?
Your Honor, Cuming is an entirely different company from Trelleborg. So
I understand, but the point is that she would have learned from that formulations of macrospheres is proprietary, confidential, trade secret information.
Well,
right?
As an initial matter, Your Honor, I'm not sure that the record would indicate to the level of detail you're talking about that the types of specifications that are involved with Trelleborg were actually involved with Cuming. And to contextualize the testimony regarding
you don't need to know that these specific specifications are confidential. You need to know, let me just cut to the chase here. Doesn't that evidence, plus the fact that she saw settlement/confidentiality agreements from two former Trelleborg employees that describe proprietary data, specifications, manufacturing techniques, etc., as confidential information. Doesn't that establish that she knew that this sort of specific formulation data of macrospheres was confidential information?
Your Honor, respectfully, we would submit the answer to that question is no. Now, to be clear, there's two elements that are missing from the government's case, and the first one is the agreement, and the second one is the lack of.
I'm going to get to the agreement in a minute, but I want to talk about whether that is sufficient to give the government adequate proof of knowledge.
We would say no, Your Honor, and the reason is because these boilerplate confidentiality agreements at Trelleborg were circular in nature. They specified that confidential information and proprietary information is confidential and must be kept confidential. The question is whether Dr. Shi thought, whether there's proof beyond a reasonable doubt that Dr. Shi would have concluded that the particular information, putting aside Cumming, the particular information that his two employees at CVMI privately used and passed off as their own constituted confidential and trade secret information. And
the particular information that his employees got from Trelleborg was the same type of information that Cumming had told them was proprietary.
I'm not sure that we would agree with that characterization of the record, Your Honor. But moreover, there's
what does the record say? Tell me why I'm wrong. What in the testimony said differently than that?
Well, we're dealing here with 7 specific pieces of information that the government has alleged constitute trade secrets and that Dr. Shi allegedly knew or believed constitute trade secrets. So if we're talking in particular about the specifications, as an initial matter, the evidence was wholly deficient to prove beyond a reasonable doubt that Dr. Shi even knew that information came from Trelleborg, those specifications.
Some of them had Trelleborg, at least one spreadsheet had Trelleborg's name on it that was emailed to Dr. Shi.
So, Your Honor, in order to develop and prove beyond a reasonable doubt knowledge that Dr. Shi thought that information came from Trelleborg and constituted trade secrets, there would have to be a string of inferences that starts with the inference that Dr. Shi opened the email. There was no metadata presented to prove that. Second, that Dr. Shi opened the native file of the attachment, because if you print it out, as many do, when looking at hard copy, you wouldn't see the word Trelleborg at the bottom.
So we can't infer that Dr. Shi read and opened an email that was sent to him. That's not what a jury could reasonably infer, giving the government the benefit of all inferences.
In some circumstances, a jury could infer that one would look at an email that they received if, in fact, there was evidence that the person reviews their email. Some people get thousands of emails, don't even review the email. So we're not willing to concede that it's a fair inference in any circumstance that opening an email means you're reviewing an attachment, means you're reviewing it in native, means you see the notation that says reference Trelleborg. It means that to you triggers another inference on top of those inferences that the information actually came from Trelleborg, and then on top of that the information constituted a trade secret and wasn't something that was even permissibly held by the person who sent it, Lou. And then
let's move on to the agreement issue.
May I ask a question first before you get into that?
Yeah.
Legal question. Counsel, are you familiar with the Curley case and the Jackson case in the Supreme Court dealing with the interrelationship between the requirement that the government prove its case beyond a reasonable doubt on the one hand, and the legitimate inferences that the government gets? Are you familiar with that case?
If Your Honor would be so willing as to refresh my recollection about the specific aspects of the case at issue, I'd appreciate that.
Well, this is a case that goes back to the 20s, written by Judge Prettyman, when it was the Supreme Court of the District of Columbia. The court was called that, but it was our court. And it's a very famous case, which has been followed by all the circuits, except recently by the Fifth Circuit. And it's basically called the equipoise theory, trying to figure out how you bring together the jury's obligation to decide beyond a reasonable doubt with, on the one hand, with the legitimate inferences that the government gets. And the law in this circuit is if the case is in equipoise, then the government loses in the Court of Appeals. Are you familiar with that case? It's certainly important to your case here.
Your Honor, I see that. I'd like to answer your question. I see I'm out of time. I would like to reserve, but I'd like to answer your question if I may. Well, we did not.
This is not a hostile question, counsel.
We very much appreciate your point, Judge Silberman, and we agree with you that in this circumstance, even if the evidence were in equipoise, then the conviction must be reversed. But we think it's actually a case that if this were a civil case, a rational jury would have ruled in our favor. I mean, the government's star witness did not.
Wait a minute. First of all, you should understand that there's a two-step process under our law, and it's backed up by the Supreme Court. The first is the government gets all the legitimate inferences. Now, you argue that some of the inferences they're asserting are unreasonable, and that's an important step. But they get all the legitimate, reasonable inferences. Then after you've done that, you compare the evidence on the other side. And if we conclude they're in equipoise, then we should reverse. That's our law. I would have thought you would have been on that, since it's certainly helpful to your case.
Your Honor, if the court would find that to be helpful, we would be happy to submit supplemental briefing on those points. But it is, we appreciate the court's consideration of those cases, and we'll certainly take a look at how they apply in the circumstances. But we agree with the court's conclusion, or Judge Silberman's conclusion, or suggestion in that circumstance, particularly when the emails Judge Wilkins was mentioning that said in a particular point, reference Trelleborg, were sent by someone that the star witness, again, Bo, denied there was a conspiracy involving. So appreciate that point, Judge Silberman.
Bo also testified that the information from Trelleborg was confidential. He testified to that at JA 1077 and 78 on cross-examination by the defense, right?
Well, Judge Wilkins, whether the information at issue is confidential is certainly a disputed issue, and depending on the particular trade secret we're speaking about, many of the Trelleborg personnel themselves, including the president of the company and the head of innovation and technology, conceded that some of the information, it was unclear if there was even a requirement that they not disclose it. For instance, some of the pricing information. Other of the information, it was unclear to them whether it even came from Trelleborg in the first place.
You're saying that there's a dispute, but that's not, as Judge Silberman pointed out, that's not what we're here to do now, is to look to see whether you disputed evidence. We're to look at the evidence in the light most favorable to the government. And what I'm saying to you is that Trelleborg witnesses, even if you could say that they weren't crystal clear that all of the alleged trade secrets were confidential, they were very clear that many of them were. And Bo, a co-conspirator, said that he believed that they were. So that pretty much demonstrates that your argument that the government didn't prove beyond the reasonable doubt that these were even trade secrets is one that we have to reject, doesn't it?
No, Your Honor. Respectfully, what the standard is, and this is in the jury instructions in the case law, particularly in the Ninth Circuit, would be that the government had to prove beyond a reasonable doubt that Dr. Shi had knowledge or belief, and the same of at least one alleged co-conspirator, that the information was subject to reasonable measures at Trelleborg to keep it secret. So the mere fact that the information could have been confidential is plainly deficient under the case law. On top of that, even if the information were confidential, and we respectfully think the evidence shows to the contrary in many of these instances, there's insufficient evidence to prove that Dr. Shi even knew the information came from Trelleborg. So
well, when Dr. Shi interviewed two of the former Trelleborg employees, they both told him during the interview that there was information that they could either had kept from Trelleborg or that they could get from Trelleborg that could help them do the job, right?
Well, Your Honor, I would suggest that it's slightly more nuanced than that. So just to be clear, Ogo, for example, it appears volunteered that there was some information he might need to, he could reach out to friends and get, but he didn't specify that that was confidential information. He didn't specify certainly that it was trade secret information. He didn't specify there was information he shouldn't be able to get from Trelleborg or that wasn't available on the internet. And then if you look at what happened next, so not only did Dr. Shi not ask him about that, never asked him to reach out to someone at Trelleborg to get information. This was just a unilateral comment during a lengthy interview. If you look at what happened next, it makes clear what Ogo's intentions were here. Ogo took the information from two of his friends, told one of them he wouldn't share, he swore to God he wouldn't share it with anyone. I just needed it because it was basic information to refamiliarize himself because he had already overstated his job.
Counsel, you're getting down into the weeds. The point I'm trying to make here is that if Dr. Shi wanted to manufacture macrospheres and he goes to the company, one of the leading company, and discusses that with them, and they tell him that the specific formulations and data with respect to that is confidential information, then he knows as a general matter that that sort of data is confidential information. And then if he goes to hire people who were former Trelleborg employees and ask them, can you help me manufacture macrospheres? And they say yes, and that they're going to use information that they either kept from Trelleborg or would get from Trelleborg to specifically help them determine the specific formulations for macrospheres, then he knows that that information is the type of proprietary information that Klayman was protecting. And by hiring them, knowing that they're going to use that proprietary information, whether they say it or not, he's entered into a tacit agreement with them to use stolen information to do the job. Why isn't that a completely reasonable way to look at the evidence in the light most favorable to the government?
Well, there are several reasons, Your Honor, and I would start with the one that the star witness, whom the government described as Dr. Shi's right-hand man, who would have been at the center of this conspiracy, according to the government, denied that there was any such agreement. So that dispels any of those other inferences that can be stacked and suspicions that a juror might consider in a normal case. This is not a case about credibility of witnesses, the weight of evidence competing.
So you say that our case law supports that if there's a denial, that trumps and overrules all the other evidence?
Your Honor, in this particular case, and in fact, in other cases that have come before this court, I think where the decisions come out is that when the key witnesses who would know whether the defendant was involved in a conspiracy and who are highly motivated and admit that fact that they would testify against the defendant if he was involved in the conspiracy, deny it, then yes, a rational juror would not be able to reasonably conclude that the defendant was part of the conspiracy. And in those cases, Gaskins and Wilson, for example, there were instances where there was evidence that a juror might consider of the kind that you just described, Your Honor, such as in Gaskins, the employee worked for a drug front. It was an investigation company. He called in plane tickets or had his name on the lease where the drugs were being packaged. There were bad facts in those cases, but at the end of the day, those who would have known and those who were called by the government in order to prove the element that there was an agreement denied that there was an agreement. So a rational juror in those.
Do you think that there should be a different rule for proving a conspiracy to participate in a drug offense than there should in a case of conspiracy to misappropriate trade secrets?
Well, Your Honor, I'd like to answer that question. Then if I may go back to some of the premises in your question, because we don't agree with some of those premises as well. But in answer to your question, we think that there is an overarching principle here, whether it be in a drug distribution case or whether it be in a murder of a witness case, as was the situation and circumstances presented in the Wilson case. But the overarching principle that one can glean from those cases is that the government in conspiracy cases chooses to charge a conspiracy, and it gets certain benefits of the doubt when it does that, as opposed to a substantive charge. And one of the things it has to prove, though it's difficult, is the agreement. So what the government does is it flips co-conspirators. And that's what it did in Gaskins, and that's what it did in Wilson. And it calls them to the stand because these are people who would know if the defendant was involved in a charged conspiracy. And it asks them that question. In almost every case that's ever been brought by the government, the answer is from the co-conspirators, yes. This is what the defendant was involved with the conspiracy. These are the conversations we had about the substantive crimes that we wanted to be committed.
So, I mean, Mr. Darrington, are you suggesting that cases like Gaskins create a kind of per se rule that when co-conspirators don't testify to the conspiracy, that there cannot be one? I mean, that seems to be overreading Gaskins.
Your Honor, it's a good question, and we certainly don't need a per se rule in order to get a reversal of the conviction in this case, which is warranted. I suppose some judges might think that this is such a obvious insufficiency and defect in the government's case when its star witnesses actually go the other way. So maybe there is some room for a per se rule here, but certainly in a sufficiency case, we don't need to rely on a per se rule here. We just need to look at the evidence in the record, the arguments in the briefs, and we think that we're confident that when the court looks at the briefs and the court looks at the record evidence, it will conclude that it is not the first court to ever decide that in circumstances presented here where the government's co-conspirators, none of them implicate the defendant, that can be upheld.
Do you think there's something about the employer-employee relationship here that further makes the inferences reasonable, where you have a small company with only a handful of employees and an employer-employee relationship where the employer is saying, you need to go out and get this type of information? And we know that he had possession of some of those documents. I mean, is there something about the employer-employee relationship that also supports the inferences?
Well, again, Your Honor, we would disagree with that premise. So Dr. Shi, the evidence is clear, didn't ask Liu to go out and get any information. He didn't ask Ogo to go out and get any information. During a lengthy interview, they volunteered that they could potentially have access to some unspecified information. But to your question about the employer-employee relationship, to the contrary, we think that actually created a lot of grounds for jury confusion here, because Dr. Shi set out to run a startup, legitimate, registered, tax-funded operation. And when you do that, you hire employees with experience. You don't hire people in a startup when you're trying to create a better product who have no experience. You want to hire people who work at good companies, have their own ideas, but have the experience to be able to make spheres. And these things were around for 50 years or so. I think it was more than that. So people in the industry knew the basics of how to make spheres. So you go out and you hire people with experience. And yes, maybe some of them will say during an interview, oh, I have friends, I have contacts, I have network, I could get other people to maybe work here too. That comes up in a lot of these interviews. But to think that a legitimate business somehow becomes a conspiracy because of the association, that contravenes settled Supreme Court precedent that says a mere association is not enough to demonstrate a conspiracy. So we're actually of the opposite mind, which is that the jurors might have seen two employees who had their own conspiracies in the case of Ogo and Uche. That was a two-person conspiracy. And then Liu, who acted unilaterally, and see that they're under the umbrella of this organization and default to some sort of respondeat superior theory of liability that imputes their conduct to Dr. Shi just because it's his company, when that's contrary to well-settled case law.
What about the fact that Shi was told that this data that they were using came from Trelleborg?
I'm sorry, Your Honor. I don't believe that that's in the record. Where specifically are you referencing?
Liu told Shi that they were using Trelleborg's recipe.
I'm sorry. Could you give me a pin site on that?
No.
Okay.
You're familiar with the record. I mean, there was it's discussed in the briefs where you say that Liu was saying that he was concerned that Trelleborg would discover Shi's recipe because Shi's recipe was better, but it's an equal inference from the testimony that Liu was telling Shi that he was concerned that Trelleborg would discover that they had copied Trelleborg's recipe?
Well, Your Honor, we think the testimony is actually fairly clear on that point. The government used the word stole in its brief, which appeared nowhere in the record when referring to that incident. And what actually happened, according to the record, is that Lou was concerned that if CBMI provided its recipe for testing and evaluation to Trelleborg, and its recipe was in fact proven to be better than Trelleborg's, that Trelleborg would see what the recipe is, be able to reverse engineer it and recreate it. But the record is clear that Lou wasn't concerned that, according to Bo, that Trelleborg would see CBMI took the recipe. Actually, to the contrary, CBMI had already provided the spheres to Trelleborg for testing and evaluation, and they came out better. So certainly if Dr.
Okay, I'm going to read to you the question and the answer. This is at JA 1077 and 78. So was Gang Liu expressing some concern that the spheres you were selling to Trelleborg had the same recipe? Yes. And this was in the presence of Shan Shi. Yes.
So, Your Honor, as we pointed out in our briefs, and I'll try to find the pin site while I speak, on, I believe it was cross-examination, Bo actually refreshed his recollection and came out the other way. He said, actually, oh, you're right. Lou was actually expressing concern that CBMI's recipe was—
So what if I don't think that if I don't agree with you that he came out the other way, if I look at this in the light most favorable to the government, what am I supposed to do with that testimony that I just read to you?
Your Honor, we think that the only reasonable inference when a witness says one thing on direct testimony, says X, and then on cross-examination, the witness memory is refreshed and comes out and says not X, and on redirect, there's no change.
I asked you a question. I'd like for you to answer my question, because I told you that I don't agree with your characterization of what happened on redirect. So let's assume that I don't. What am I supposed to do with that testimony that I just read to you?
You mean cross rather than redirect, don't you?
Or cross, yeah.
So, Your Honor, I want to make sure I'm answering your question properly. So, is the question that if Bo's testimony that Lou was concerned were not refreshed and updated, changed, depending on how you look at it, what should the court do with Lou's initial testimony?
Yes.
Well,
doesn't it establish that she was told that they were using the same recipe as Trelleborg?
So putting aside our obvious disagreement with the premise of the question, if the testimony had stopped after the initial Lou testimony, the first thing we would point to is the fact that Bo, who was the very person testifying here, already said, he testified very clearly, there was no agreement involving Lou to steal trade secrets. So you could take your initial inference and compare it to the fact that there is no agreement, and it clearly dispels, this is not competing inferences. One piece is a direct testimony from the charged right-hand man in the middle of the conspiracy saying, you can't make that inference. And that wasn't crossed by the government. So the second point is that even taking that initial Lou testimony, we don't think that actually would constitute, putting aside the refreshing of the memory, an admission that this data came from Trelleborg, or that Dr. Shi knew it, or that Dr. Shi actually agreed to it. Even in this kind of a different factual scenario than is presented here, the case law is clear that even acquiescence or approval in the substantive crime is not enough. It's not an agreement.
All right, thank you. Any other panel members have questions?
No.
Go ahead.
All right, we'll hear from the government.
Thank you, Your Honors.
Good morning, Your Honors. May it please the court. Sonia Ralston for the United States. I'd like to pick up where the panel left off with one clarification about the record. That on redirect examination, there was further clarification in Bo's testimony at pages 1154 to 1155 of the joint appendix. They talk about, what was Gang Lou's concerns in the conversation? Answer, about doing that TGA test. Trelleborg might be able to find out the recipe of CBMI. Question, and was he concerned about whether Trelleborg would know its own ingredients were in that recipe? Answer, yes. And then he says there's a different test question, and that's a different test from the test in the email that Mr. Zeidenberg, the defense counsel, showed you. Yes. So even if you want to take the legal premise of defense counsel's argument, the factual premise is not true. It was clarified again on redirect examination, and Bo is very clear that this oral conversation occurred after the email that's referenced on cross. And in that conversation, Lou was very clear that the test Trelleborg could do would identify that its being belonging to Trelleborg's recipe was being used to manufacture the spheres at CBMI.
Counsel, I have a number of questions for you. First, I'd like to ask you, you cited two prior cases. They're not particularly relevant or crucial. One of them, you parenthetical that Kavanaugh had written the opinion, and the other, Ruth Ginsburg. Why did you do that? Why is that relevant? The two colleagues of ours who went to the Supreme Court decided that case or wrote the opinion. Why is that relevant? You realize that we're all equal black robe judges? Did you think we should give particular deference to the fact that a prior colleague who's now a Supreme Court justice or was a Supreme Court justice wrote the opinion?
No, Your Honor, not as special deference. It's just a fact that courts are sometimes interested in. It occurs often in court opinions.
Not appropriately interested in. I think it's Bush League advocacy. Any event, let me start. That annoyed me right at the start. But let me go on to say, I want to pick up on a point that my colleague raised, which I think it's the key to the case. On page 22, you say, first, she was the micromanaging boss of a very small company in which two other members pleaded guilty to the charged conspiracy. Isn't that absolutely illegal for you to state that? If that argument had been made to the jury and there was an objection, what would the district judge have said?
I'm sorry, Your Honor. The fact that Ogo and Bo pleaded guilty was presented to the jury. It was testimony.
And what was the instruction the judge gave concerning that?
I don't have it at my fingertips.
Well, I do. It was that you cannot use the guilty plea of these other two against she, and yet you're doing it on appeal.
Your Honor, it's not. I disagree, Your Honor. It's not substantive evidence of she's guilt. It is evidence that in this company, this is not a 500-person company where he might have no idea what's going on. It's a very small company where there are only a couple of people, and essentially everyone else.
Isn't it correct, counsel, that the district judge properly instructed the jury they could not take into account in determining whether she was part of a conspiracy that two subordinates had pled guilty to a conspiracy?
That's correct. The mere fact of their plea is not substantive evidence.
So then why are you using it on appeal?
Your Honor, it's shorthand for the fact that they admitted that they were involved in a conspiracy, which they did when they testified.
It's absolutely improper to infer that she is part of a conspiracy. If you had made that statement as counsel before the jury, there would have been an immediate objection and a move for a mistrial.
Your Honor, they testified that they were guilty of the crime charge. That doesn't mean that she was necessarily guilty, but it is evidence that
no, it's not evidence. It's evidence that the district judge properly instructed the jury they cannot use that factor as evidence against she. And yet you're using it on appeal. Now, I suspect that that's exactly why the jury decided as it did, but that's improper, isn't it?
It is improper to convict someone of a conspiracy merely because their co-conspirator has pleaded guilty. That's true. But I think even as my friend on the other side would agree that if someone testifies, I joined a conspiracy and the defendant was in it with me, that the jury...
Wait, that's not the issue. You're saying here in your brief that because two other members plead guilty to the charge of conspiracy and a very small company, that could be used against the boss, Shi. And that's improper. That's grotesquely improper.
Your Honor, I apologize for the wording. The point is that two other members of the company that only had 4 people in it were involved in the conspiracy. They testified at trial about what was happening at the company, about their actions, and about what happened in front of Shi. The point is, Your Honor, that in this tiny environment, it is simply implausible to conceive that she did not understand what was going on.
I see. I guess we will just be in disagreement about whether what you did was appropriate. Let me go on to some of the other statements you make. In your statement of facts, you're accurate, but in the body of the brief, it seems to me you make some misstatements. Let me start with Ogo and Liu, who both told him during their interviews that they would need Trelleborg data to do what she wanted them to do. Isn't that incorrect?
Ogo testified that he would need the data to compare with. That's at 1168. And
Leo did not say he needed Trelleborg data.
He said that he had kept the technical data.
Yes, but that is not the same thing as saying he needed Trelleborg data. So you misstated that.
I apologize, Your Honor.
And no, Ogo didn't say he needed Trelleborg data.
I believe he said I would need the data to compare with.
He would need data to which he would compare the sphere he produced.
And that he could get the data from Trelleborg.
No, that's not what he said. He had friends at Trelleborg that he can contact to help him get the data. Now, that data could be public or could be spread throughout the industry.
Your Honor, I disagree that that's a fair inference.
Now, you might have argued that there's a fair inference, but you've stated flatly, which is a misstatement, that Ogo and Liu had told them during the interview that they would need Trelleborg data to do what she wanted them to do. So I'm very troubled that that's a misstatement. Now, you might have argued that a legitimate inference of the could be raised to that, but you didn't say that. Now let me go on. You said she paid Ogo substantially more than he was paid at previous jobs. What record evidence do you have of that? Isn't that a false statement?
No, Your Honor, it's an inference.
What do you mean it's an inference? You said she paid Ogo substantially more than he was paid at previous jobs. Do you have any evidence to support that?
The evidence, the testimony, I'm looking for the page, I think it's 1069, is that he was paid more. The modifier is an inference.
It could have been $10. You never asked the question, how much more? It could have been $10. So where do you get substantially more? That's a misstatement too, isn't it?
Your Honor, in the argument portion of our brief, we're arguing the inferences that support the
No, you didn't say this is an inference. You said she paid Ogo substantially more. That's a factual statement. It is not supported by anything in the record.
The modifier is not in the testimony.
You're darn right. It could have been $10. And obviously it wasn't very much because you would have asked the question at trial. Now let me go on. You say she initially did not think Leo would be a worthwhile hire and changed his mind only after he learned that Leo had kept Trelleborg documents. What is this business that he changed his mind? I don't see that.
Your Honor, he initially did not think Lou would be worth hiring because he didn't have a PhD, and then he hired him. No, that's
correct. That is not correct. He wouldn't have interviewed him. He knew before he interviewed him he didn't have a PhD. And he thought he might be a worthwhile hire down the line, just based on his record. So he liked him. So it's not fair to say that he changed his mind about Leo being a worthwhile employee after he interviewed him. He wouldn't have interviewed him without thinking he was a possible. So again, you're exaggerating.
I disagree, Your Honor. Even if he thought that down the line Lou might be worthwhile, the fact that he hired Lou immediately after the interview and then didn't even wait for the conflict check indicates that he did have a change of heart.
It's your statement that bothers me. She initially did not think Leo would be a worthwhile hire. That's not supported.
Bo testified that when he first showed Lou's resume to she dismissed him because he didn't have a PhD.
But he wouldn't have interviewed him if he didn't think he was worthwhile.
Potentially in the future.
So in other words, you might have argued there's an inference you could draw from there, but you made a statement of fact, which is an exaggeration at best. Oh, now here's one that's more serious even. At page 19 of your brief, she hired both men knowing they would use Trelleborg secrets to do their work for him. No record citations there. Isn't that a dreadful overstatement? She hired both men knowing they would use Trelleborg secrets to do their work for him.
Your Honor, that's our argument of what the inferences from the evidence proves.
That's not what you say. That's not what you say.
Respectfully, Your Honor, this is in the argument section of our brief. It's the argument.
I know that you might legitimately argue there's an inference, but you made it as a statement of fact. And it's also quite a stretch. Now, let me go on. Because this is another statement in your brief. It was obvious that trying to extract the spheres would damage them beyond the point of useful reverse engineering. Is that obvious? Where is that in the record?
Kip Carlisle testified that if you try to take the foam apart, the spheres rupture and break, and then you can't test them or see what their density is.
Actually, his testimony is some reverse engineering like that is possible at varied expense, depending on how much you need to know. So again, there's nothing in the record can be true to suggest that it's obvious that it's impossible to reverse engineering spheres. So that's a misstatement too, counsel.
Your Honor, there was testimony about how the DBRMs are made when you put the resin around the spheres, that it's liquid and then it solidifies and it's hard.
I understand.
I think it's obvious that if you try to break hard plastic, it splinters.
You think it's obvious, but you don't have record testimony for that at all. You have no record reference at all. And you don't argue that this is an inference I can draw from something that this is just obvious. It's not obvious at all. The testimony is contrary. Okay, how about Ogo was sending Shi testing data on spheres when CBM International had no manufacturing capacity to make spheres? This is unsupported, isn't it?
It's not, Your Honor. He sent the data in January 2015, and there's testimony that they didn't develop the laboratory capacity to make the spheres until April. And that at that time, they were still trying to set up a lab.
But Ogo testified that he deleted all confidential testing data and produced his own results, which he sent to Shi.
He produced a template.
So he didn't. Why would he delete all confidential testing data and produce his own results if Shi was part of the conspiracy?
So this is Exhibit 25 that we're talking about?
JA 1176.
Right. So this is the test procedure, and he takes it to make a template that he can use to show Shi that how they do the test. I think if you look at the 7 trade secrets, that's probably the weakest of them.
Point is, if Shi is part of the conspiracy, why the devil would Ogo eliminate any reference to confidential testing data?
He testified several times that he eliminated the Trelleborg markings and data, the markings that identify things as Trelleborg, because he knew that she was going to send them outside, he says, at 12:09. And he testifies.
But that suggests that he didn't want that she wasn't part of the conspiracy.
Respectfully, Your Honor, they made that argument to the jury, and the jury didn't buy it. I think the jury was entitled not to believe it, and that this court, on the deferential review that we're here today, should let the jury have that choice.
Yeah, that's possible, but that's a legitimate argument, but that's not what you said in your brief. How about Ogo was prohibited from appearing at the company's booth, even though he knew the most about the product. Now, the evidence is that she explained that he wanted a Chinese national who speaks Chinese to represent him at the China pavilion. Now, the jury's entitled to reasonable inferences, but isn't it much more reasonable that she did not want Ogo to appear because he didn't speak Chinese? It's such an obvious reason.
Your Honor, I'd like to combine that piece of not appearing at the convention with two other pieces of evidence, which is that she told Ogo not to tell the phone suppliers that they were trying to make macrospheres, who knew that Ogo might have worked for Trelleborg, and that when she hired Lou, he hired him at a different company to hide the fact that he was working for a Trelleborg competitor. So when you put those three things together, I think it's a fair inference that the jury could draw that what she was trying to do was hide the fact that he was using former Trelleborg engineers to produce this product.
Well, I finally make the point that throughout the brief, you make the insinuation that the guilty pleas of the subordinates should be considered by the jury in determining whether she was part of the agreement. And that, I think, is possibly what happened in the case, but it's certainly inappropriate. Now, one last point here. No, I have a few more. You have a statement on, well, we've already talked about Bo. Oh, I know, here it is. This is your statement. Bo testified that he did not agree to steal the technology, but admitted in his plea agreement to have committed the charge offense, which includes possess. Thus, the jury could either have interpreted Bo's testimony in light of his plea agreement and conclude that Bo agreed to take the trade secrets, discount Bo's testimony, and credit his plea agreement. Now, again, you're using the plea agreement against Shi. Isn't that improper?
No, Your Honor, we're using it to assess Bo's credibility, which is the proper use of a plea agreement admitted against a testifying witness. His credibility, where he's saying something in his testimony that, arguably isn't, you can interpret that he's just asking about steal, and so that he's not saying he's truthful when he says we didn't steal.
Do you think that's a reasonable inference? That was a point that was discussed with your colleague. But you think that's a reasonable inference that he would be so sophisticated a lawyer that he would distinguish between steal and use?
I don't think it takes sophistication to see the difference between steal and possess.
Doesn't it suggest that the government didn't ask him that question because it didn't want the answer?
Your Honor, I think that goes both ways. The defense only asked about steal. They didn't ask about the 7 other verbs. And you're right, it wasn't addressed on redirect when it could have been, but I think the redirect was focused on things that were more interesting about this testimony, like the conversation with Lou about testing.
All right, let me go on to my last point. You say in your brief, the evidence established that Shi's plan for growing a drill riser buoyancy models was to misappropriate other technology. Isn't that false? Is that statement accurate?
I'm sorry, where is that in the argument section?
Page 24 of your brief.
Right, okay.
The evidence established that Shi's plan for growing a drill riser buoyancy modules was to misappropriate others' technology.
So I think that's a fair inference from the testimony, from the record, from all of the documents.
Of course, it would be appropriate brief writing to argue that there's an inference here, but you just stated it as a flat fact.
Your Honor, when I say the evidence established, it's fair to say that the circumstantial evidence established, as this court's precedents say, direct and circumstantial evidence are on equal footing. So we look at the circumstantial evidence, I think it does establish that that was his plan, because the circumstantial evidence is that he interviewed these people, and when Ogo said, I'm going to need Trelleborg data to do my job, he hired him anyway. And when Lou said,
that's an overstatement.
I kept the data.
He did not say, I need Trelleborg data to do my job.
Your Honor, he said, I need the data. And then the next sentence is, and I could get it from my friends at Trelleborg.
What did he say exactly?
It's at 1168. So the data you said you would need to compare with, is that something you said during the interview? That's correct. And did you indicate where you would get the data from? I remember saying that, yes, I have friends at Trelleborg that I can contact, yes. And did you explain what you needed the data for? Why did you need it? And then he goes on to explain how complicated it is to make the spheres.
Yes, but first of all, that doesn't refer to trade secrets, number one. Number two, the data could be generally known in public information.
Two responses, Your Honor. I think if it were genuine, if it were publicly known, if he could get it off the internet, he wouldn't say, I could get it from my friends at Trelleborg. He would say, I could get it off the internet.
My friends with Trelleborg would help me finding it. That doesn't mean it could come from Trelleborg.
Your Honor, that's a competing inference that could have been drawn, and they argued that to the jury, and the jury rejected it. And the second point is that when they...
I agree, but if I had been writing the brief, I would have argued that an inference rather than making a statement of fact. Anyway, that's not the most important thing that bothers me is your argument in the brief that would have been almost grounds for mistrial presented before the jury. All right, I'm finished questioning counsel, but suppose I conclude that in your argument, you've made a number of misstatements. How does that weigh in determining whether you should prevail in this case or not?
Your Honor, I apologize sincerely that it
no, I'm asking
came off that way. And
I'm correct that you've made a number of misstatements. Does that weaken your case in the Court of Appeals?
No, if the court feels that I've handled myself poorly, then I apologize, and I will tell the department that. But you should not hold my behavior against my client. If the evidence is sufficient, the evidence is sufficient.
Well, this is I have to look at the case as between two parties. If it was a civil case in which one of the parties made misstatements in his or her brief, I would hold that against the party.
Your Honor, we pointed to the record citations that we believe support the argument. In the beginning of the argument, we identify the law that says that the standard is to take the inferences in favor of the verdict, and that's the premise on which we made the argument.
Okay.
That is the law, and I think that's...
Are you familiar with the cases that I referred to when questioning your colleague?
Mm-hmm. I am.
And the way in which we should, as appellate judges, look at this case, we give you all reasonable inferences and then conclude if the inferences or the evidence from the other side is in equipoise with yours, then we have to reverse. You're familiar with the Curley case?
Yes, Your Honor, and I understand that principle. And as Your Honor articulated, the critical first step is to take the inferences in favor of the verdict. I think when you do that here, the evidence is not in equipoise. That the defense made a bunch of arguments to the jury, and they were reasonable jury arguments, and the jury rejected them. And at this point, the opposite inferences are in order.
Isn't the most important evidence that they had is your own witness, Bo, testified there was no agreement? I know you make the distinction between steal and use, but I don't think that's a reasonable inference. So if that's the only testimony, whether or not there was an agreement, and it runs in favor of the defendant, why isn't it necessarily the case in equipoise?
So I have two responses, one factual and one legal. The first is that, as the district court noted, that also could refer to whether there's a written or formal agreement, and that's not required.
I frankly think that's almost a ridiculous inference.
The second legal point is that there's no requirement that that we even put on cooperators or that we have somebody answer that question. The question is, when you look at all of the evidence together, is there evidence that the defendant agreed? And there is. If you look at all of the information that he sent, the emails, there are several emails that say this information is from Trelleborg right in the email. You don't even have to open the documents.
You're talking about the reference at the bottom of the page that only
No, Your Honor. No, I'm not. So put that to the side for the second. You have at page 362, they're talking about the email. In the body of the email, it says the information received from Trelleborg. And then you have, again, when they're talking about Exhibit 144, they say the reference standard of Trelleborg, and that's in the email. That's at page 378 of the record. What Lou says, what I provided was the protection standard of Trelleborg. And that information, there's testimony at trial, matches exactly some information at Trelleborg and is substantively the same as the information in Exhibits 28 and 30, which is Trade Secret 4. And that information, I think that's probably the strongest one if you look at that for his knowledge, because he takes 28, which is when he gets it from Lou, and he doesn't just forward that email where you could infer that he didn't look at it or anything. He takes the document and then attaches it to a new email and sends that on to Bo. I think that act makes it much more likely that he opened the document. When you open it, it's very obvious. Right at the bottom, it says reference Trelleborg. And also, that's the home run data that tells you, the density of the spheres to where they're going to survive. And the fact that they survive under pressure is the most important part of making a reliable product. If it's not going to survive under pressure, it can't do its job. And then you get the other data that says how many coats you have to put on it, which, given the amount of competition between these companies, it's really important to not use more material than is necessary because it's really expensive. So knowing the exact number of times to coat the sphere saves you a lot of money and a lot of time in having to figure that out. I think also in their reply brief, they want to say that we've misrepresented that Lou kept the data. And I think if you read the whole sentence at page 1066, Bo testifies. She says, yeah, Gang Lou is the guy we've been looking for. And also he mentioned Gang Lou kept some technical data from Trelleborg. So it's all one piece right there altogether, that this is the same thought. I think the evidence, if you put it together, is, I think, clear, but at least rational for the jury to have concluded that she was guilty.
Any further questions, Judge Rao? Judge Silberman?
No, I don't.
All right.
Again, I apologize, Your Honor, for the wording in our brief.
All right. Thank you, Ms. Ralston. All right, Mr. Darrington, you were out of time, but we'll give you 2 minutes on rebuttal.
Appreciate that, Your Honor. Just a few quick points I'd like to cover. First, appreciate the panel's careful review of the record in this case. It is extraordinarily complicated. There's thousands of pages and exhibits, and that's one of the reasons we frankly think the jury just got it wrong respectfully. It's one of those cases. Second, the government argued it's implausible that Dr. Shi didn't know that this was going on at his company, but that statement there is almost a concession in its own right. Carelessness and not knowing that your employees are committing misconduct or not connecting the dots, as the prosecutor expressly said in closing arguments to the jury, is not an agreement. And that seems fairly clear in the case law. As to the government's point about circumstantial evidence, it's all belied by direct evidence. And while the government is correct that they weren't required to call the co-conspirators, they did. And their own co-conspirators admitted that they were highly motivated to testify against Dr. Shi for, frankly, some fairly particular reasons. And still, one of them denied it, and the other didn't testify there was ever a conversation or agreement about stealing trade secrets. Third, as to the point about Mr. Ogo's removal of the Trelleborg notation before sending it to CBMF, not Dr. Shi, his explanation is simply nonsensical. I mean, CBMF was charged as a co-conspirator, so it doesn't make sense that Ogo would remove the notation to try to hide it from a co-conspirator. As for Trade Secret 4, as we note in our brief, it's unclear that information even came from Trelleborg, let alone was a trade secret. And finally, as to or penultimately, as to the reasonable measures argument, because we didn't get up into that much in my opening argument, that's our second argument, and there's just no evidence, certainly not enough to prove beyond a reasonable doubt, that Dr. Shi had knowledge or belief that there were reasonable measures or what they were to keep this information secret. And the government didn't even argue it as to an alleged co-conspirator, which we submit as a waiver on that point. So unless the court has other questions, we really appreciate.
Would you repeat that last point?
Yes, Your Honor. So we argued in part for our second argument that there was insufficient evidence to prove beyond a reasonable doubt that Dr. Shi and at least one alleged co-conspirator knew or believed that the information at issue constituted a trade secret, which is a statutory term that's defined within the meaning of the statute. And from our review of the government's briefs, we actually think that is waived. We didn't see this fleshed out in argument, any grounds or reason why there was evidence that a co-conspirator had that knowledge or belief. It's simply something the government chose not to respond to. And we think that was for a good reason, because there was little, if any, evidence that a co-conspirator knew or believed the information at issue was subject to reasonable measures to keep it secret. That's prong A under 1839(3), or B, and this is less of our argument, but was independently economically valuable, and that just applies to certain of them. But the first one, that there were no reasonable measures to keep it secret, while the government only needs to prove knowledge or belief that there are reasonable measures, not actual reasonable measures, it failed to satisfy that requirement. And in fact, many of the alleged co-conspirators here worked at Trelleborg, so they would have known the fact that this information wasn't kept secret. For instance,
if a co-conspirator says that the evidence was confidential, you're telling me that that's not evidence that the information was subject to measures to keep it secret?
Well, Your Honor, I'm not sure where in the record one of the co-conspirators said confidential information that was provided to Dr. Shi was confidential, or that he knew it was Trelleborg.
Let's assume that there is evidence in the record of that.
Well, then, Your Honor, no, the answer is no, because the statute, and this has been litigated as to jury instructions, in fact, in this case included, the case law is fairly clear, we think, that what is required is that Dr. Shi and at least one alleged co-conspirator knew that it was a trade secret, not that it was confidential. The government has frequently argued that all that is necessary is that the government prove that the defendant knew or believed the information was proprietary or confidential, but that's not what the statute says. The statute defines trade secret, and it defines it in such a way that it has to be subject to reasonable measures. So in most cases, it's fairly straightforward. Most of the cases that involve conspiracy to steal trade secrets, the defendant is a company insider or a former company insider, and it knows exactly how the information is treated. It's highly unusual for the government to charge a conspiracy involving an outsider to the company who didn't pay someone inside the company for the information. For example, exchanging a briefcase in a hotel room in one of the cases in order to get the information, knowing that it was subject to measures to keep it secret. So here, the government's trying to build this connect the dot theory of Dr. Shi's knowledge and agreement, and it just stretches the evidence way too far.
I go back to one of the first questions that I asked during your opening argument, which was that she started out by trying to get this sort of data from other companies and was told that we're not giving you that data, that you can't have that data.
Well, Your Honor, in that particular situation involving Cumming and Mark Schlegel, who I believe was then president, Schlegel was trying to pitch, according to the evidence, a joint venture in which he was going to receive $6 million for a couple, he and his partner, $6 million for a couple months of work. So it's not something that Dr. Shi would have necessarily agreed that whatever unknown data, and I don't think it's clear from the record what Cumming was referring to or whether it was analogous to the data at Trelleborg, was trade secret data. But even if it were, just to be clear here, Your Honor, if Trelleborg doesn't keep the information secret and Dr. Shi doesn't know that that Trelleborg kept the information secret, he doesn't have the requisite knowledge. And the government could have come in here. They could have put an expert on the stand and said that Dr. Shi, with his background and his experience, would know that this information, A, could not have been developed from CBMI, and to the contrary, as a footnote.
They don't need an expert when they can just argue the same thing from the inferences. I mean, what do we do with the fact that there are only 4 companies in the whole world that create these spheres? So we're supposed to say that the critical data that you need to produce these spheres is public, and that's why only 4 companies can do it?
Well, Your Honor, just to clarify, CBMF, the parent company to CBMI, is a large, notable corporation that has a long history of creating manufacturing in the sphere space. I believe it was
the testimony was that none of their spheres were qualified. You say that in your brief, and I don't have time to go through all of the misstatements in your brief, but the testimony in every instance that you cited, the person qualified it and said that they specified that the spheres that were created by the Chinese parent were not qualified spheres. Am I wrong about that?
Your Honor, I'd have to check the PIN site to be clear to confirm that, but I have no reason to necessarily doubt that your characterization of the testimony. But CBMF, the point is, this is not a fly-by-night operation, CBMI, that sprouted up and suddenly started trying to.
Well, if they could create these exact same spheres and be commercially successful at doing it, then why did they hire Dr. Shi and create this company?
Well, Your Honor, we're not
to figure out how to make them.
We're not.
My point is that there's 4 companies in the whole world that makes these spheres, but you're arguing that somehow it's a stretch for a jury to infer that the precise data that you need to make them is really a trade secret, even though there's only 4 companies in the whole world that can make them. That's your argument?
Your Honor, we're not arguing that CBMF was fully capable of manufacturing the high quality spheres that CBMI did that exceeded Trelleborg or any of that. We're just arguing that this is the notion that CBMI had no resources. It was a startup that was heavily funded by a parent company that had a rich history of manufacturing. But to your point, the fact that there are 4 companies that create these spheres, I mean, these have been around for a very long time. This is not some new technology that you had to either license the information or steal trade secrets in order to do. Like any startup in an industry that has some saturation, frankly. I mean, there were 4 companies, but these were large companies. And like any startup, what you would do is you would proceed by you would consider as a business person whether you could cheaply license the technology. And they found out that wasn't the case. So you hire people who already have the experience and know-how to come up with their own ideas about how to develop an already extant process in a way that it actually exceeds the quality and is cheaper than all of the competitors. And that's exactly what they did. So the notion that Dr. Shi, just because someone, Mark Schlegel, told him we have some information that we're willing to go in on a joint venture, and we're not going to tell you that. I don't think you can transpose that to a different company involving a different set of circumstances and say that's enough to satisfy a statutory element that Dr. Shi knew or believed, and at least one alleged co-conspirator knew or believed the information constituted trade secrets, especially when you have an avalanche of evidence to the contrary, such as...
All right. You've answered my question. And you've gone well over your time. We'll take the case under advisement. Thank you, counsel.
Thank you very much, Your Honors. I appreciate it.
Would you give me a moment to collect my
Yes.
files? The home office is not as effective as the court. Is the aircraft case now? Yes.
Yes.
Okay, I'm ready.
All right. Please call the next case.
Case number 20-1013, Aircraft Service International, Inc., doing business as Menzies Aviation et al., petitioners, versus Federal Energy Regulatory Commission and United States of America. Mr. Field for the petitioners, Ms. Berry for the respondents, Ms. Hoff for the interveners.
All right. Good morning, Mr. Field. We'll hear from you.
Thank you, Your Honor. May it please the court. In the proceedings below, FERC found movements of jet fuel that undeniably originate outside of Florida and terminate within Florida to nevertheless be interstate movements because the product enters a terminal at Tampa, Florida, before continuing on to its ultimate destination at Orlando. A century of precedent construing the Interstate Commerce Act dictates that the jurisdiction of a multi-part movement such as this is determined by whether the shipper of the product has a fixed and persisting intention to move product through the terminal storage to its ultimate destination. FERC explicitly found that the airlines in this case have an overarching intent to move jet fuel from out-of-state sources to the Orlando airport, and furthermore, that they execute this intent in the most efficient and economically practical way. But not only did FERC not conclude that the airlines then have the necessary fixed and persisting intention, but it found that these facts do not address the jurisdictional question of the transportation over Central Florida pipeline. It reached this inexplicable result only by ignoring the rich precedent left by the Supreme Court, the Interstate Commerce Commission, and its own decisions, and then incorrectly and myopically applying a mechanistic three-factor test. FERC's critical error appears in paragraph 122 of its order. In rejecting the relevance of its own finding of overarching intent, FERC states that the airlines accomplished their overarching intent to supply their planes at Orlando through two distinct movements. First, a foreign interstate movement to the Tampa terminal, and an intrastate movement from the terminal to the airport by pipeline or truck. The question, however, is not whether this movement occurs in two separate movements. It's whether both movements serve the same purpose. And the findings by FERC on the record undeniably demonstrate that there is no purpose behind either of these movements other than to move jet fuel to Orlando from out-of-state sources.
But Mr. Field, isn't part of the purpose, as you said, to create an efficient and economical way of moving this? So there is some other intent besides just moving it to Orlando. There is, an intent to do this in a particular way by storing fuel at Tampa before it goes on to Orlando.
There's two responses to that. The first is that the intent is to move the product to Orlando efficiently, and that intent is carried out. As far as storage at Tampa, there's no evidence that there's an intent to store product at Tampa in this case. the fuel is not needed at Tampa. And in fact, it's essentially impossible to store the fuel at Tampa because of the volume that moves through every month.
Doesn't it stay in Tampa sometimes for a long period of time, up to 12 days?
The fuel moves through Tampa continuously. It sometimes takes 10 to 12 days to move through the
well, wait a minute, 10 to 12
days. The product is
no, Council, 10 to 12 days in the tanks is not continuous movement. And here's my question about your overarching intent. If that were a proper interpretation of the statute, wouldn't all the cases, such as Atlantic, be decided differently? If that was, isn't it the real question whether there's continuous movement or not? And it's an objective test that determines so-called intent. It causes a little confusion here, but I use the word intent. But the key is whether there's continuous movement or not.
To the question of continuous movement, there's no case that holds that the fact that a product stops during its movement defeats the continuity of movement. That's the Settle case from the Supreme Court.
What about
Atlantic? Stopped in Carson, it stops in Sabine.
What about Atlantic?
Atlantic Coast really highlights what the difference is between a continuous movement and one that's conducted in two legs. Atlantic Coast found that the entire purpose of bringing the product to the terminal storage was for Standard Oil to conduct a marketing and distribution business out of that terminal. It then delivered product to 127 different locations, and it did that based on needs of customers that might arise and that were not planned before the product was brought into the terminal.
But there still was an overarching intent to get the gasoline to the stations, right?
The overarching intent was to run a marketing and distribution business out of the seaside storage. If you look at the other cases that have held it.
Am I wrong? Wasn't there an overarching intent to get the gasoline to the stations?
There was not a primary intent to get the gasoline to the station. The intent was to bring it to storage so that there would be enough product in the seaboard storage that when need arose at those stations, it could move that product to those other stations.
Isn't that how how this works here as well, right? Fuel is sent to the Orlando airport as the different airlines need it. I mean, isn't that part of what FERC found?
Yes, and it's also ordered based on what the airlines need. I mean, it's all driven by what the airlines need at Orlando. So they look at what they need, how much fuel they need at Orlando in a month. They ordered that amount of fuel to come to Orlando that month. It can only move through as fast as product is being consumed because there's already fuel at Orlando. It's a constant process. This has been going on for decades where you've got planes flying out of Orlando, consuming fuel. As they consume a day's worth of fuel can come in. It's just a cyclical process. And of course, it has to come to Tampa before it can move on to Orlando. There's no other way to get it onto the pipeline.
Well, of course, if it was shipped immediately, the fuel was shipped immediately to a connecting pipeline and then on to a pipeline to Orlando, then you would have a different case. The problem is, did you have a sufficient stop in Tampa to break the continuity? And all the Norville factors run against you. You don't deny that.
I do deny that the Northville factors run against us. The question that is present throughout all the precedent here is whether there's intent to move the product through the terminal to the ultimate destination.
No matter how long it stops at the terminal?
Certainly 10 days has not been shown to disrupt the transportation. There was 1 to 30 days in Sabine. in Department of Defense versus interstate storage, it could be stored up for 2 months. If you look in Northville, there was a system where the product was stored for months on end in off-peak periods, and the entire intent was to store product at the terminal so that it could be used months later during peak periods. Those facts just aren't present here. What our case has in common with all the other cases finding transportation jurisdictional is that the product was ordered specifically for use at an inland destination. The product moved through the terminal. There was never any question that the product would not move through the terminal. There's no other business occurring at the terminal. There's no sales there. There's no marketers that operate out of the terminal. There's no distribution business operating out of the terminal.
Wait a minute. There was distribution out of the terminal. What about 10% of the fuel is sent to, not to Tampa, but to other locations in Florida? In Florida.
Sure. So first of all, there's 2 airlines that only moved the product to Orlando, that never moved to other airports. Second of all, any product that's delivered to another airport was ordered for use at that specific airport. In the record, the initial decision looked at the nominations that Delta submits. This is in paragraph 127 of the initial decision. It sets forth the particular volumes for each of the airports it supplies from Hooker's Point. It sends a nomination that says, I want this much at Orlando, this much at this airport, this much at this airport, and that's where that fuel ends up.
Counsel, what about my question? Isn't it true that a certain amount of fuel was sent from the Tampa terminals to other locations, not Orlando?
Yes, it's sent to those airports that those airlines, for instance, Delta, ordered the product.
So Tampa constitutes a distribution location as well as a transshipment location to Orlando.
There's no precedent that any party has relied on this court that finds an analogous situation.
There's something wrong with this.
A distribution point.
May I ask the presiding judge, is there something wrong with our system here? Does counsel not hear my questions?
I believe everything the audio is working. Mr. Field, if a judge asks you a question, you should stop speaking and let the judge have the floor. All right. So Judge Silberman, why don't you ask your question?
Well, now I can't remember the question, so it'll come back to me.
I believe you asked that.
Excuse me. Have you argued here before?
No, Your Honor, I have not.
Well, it is de rigueur that when a judge asks you a question, you stop. And I must say, because of our new technology, I was confused as to whether my voice was even coming across. Because typically when a judge asks a question, experienced counsel will stop talking.
I apologize, Your Honor. I did not hear that your question was coming while I was trying to answer your question. The question I thought I was answering was whether product goes to destinations other than Orlando.
And what's the answer?
The answer is that it does go to destinations other than Orlando because it's ordered by those airlines for their consumption at those destinations. The process is exactly the same as what goes to Orlando. And if you look at the Delta nominations that were detailed in the initial decision, the nomination specifies specific quantities to go to the different airports. And so from the time it's ordered, it's always known that that quantity of product is going to that particular airport. That's just a separate mode of transportation from the product that's going to Orlando. What's ordered from Orlando goes over the pipeline to Orlando. What's ordered for the other locations goes from the ship into the terminal to those other locations. It's the same process.
Counsel, what is the point you were making that the Norville factors don't apply? No, not the argument that the Norville factors should not be used exclusively, but your previous argument that under the Norville factors, you should prevail. Why do you say that? Which one of the Norville factors points in your direction?
The first Northville factor is whether there's a specific order for a specific quantity of product to move through the terminal destination. As I just explained, the airlines nominate specific amounts of jet fuel every month that they nominate based on what they plan to move through to.
But isn't that only an estimate, a rough estimate? It doesn't coincide exactly. It's not specific.
It's an estimate based on the airline's anticipated needs, and those estimates prove to be pretty accurate over time. And FERC has never before found that you need some sort of exact 100% match between the order and what actually comes through. In Carson Petroleum, there was a 10% discount. There's numerous cases coming out of the ICC where there's some difference between the amount that was ordered and that ultimately came through, but there was no question that those were still specific orders.
Counsel, so you think the first factor in Norville is satisfied because there's a specific order for specific amounts to be sent specifically to Orlando. Is that your view?
Yes, Your Honor, it is. And on the second factor, the question is whether there's a marketing distribution business. FERC found that there's not a marketing and distribution business in the traditional commercial sense going on at Tampa. Now, I don't know what other type of marketing distribution business that they're looking at, but we know that there's not one in the commercial sense, and there's no marketers that operate out of Tampa. There's no, there's no general distributors of product that operate there. Everything that comes to Tampa is brought to Tampa because it was ordered by an airline for use at an airport, and the product goes to the airport that the airline ordered it for. And it goes in a short period of time, much less time than it takes product to move through in other cases in which FERC has found the transportation jurisdictional. FERC states that the recurring pattern of shipments here are irrelevant. It says that in its brief. The recurring patterns of shipments show that you've got this constant flow of fuel coming through Tampa to defined destinations that it was ordered for and where it's consumed. Each airline has a specific intent to bring jet fuel from out-of-state sources to Orlando over the pipeline to fuel its planes at Orlando.
What about the third factor?
The third factor goes to whether arrangements have been made for the transportation beforehand. And there's a great deal of record evidence on this point, most of which FERC just decided to not go to that factor. The judge herself stated that she looked only at the arrangements from the tanks to the terminal and not at the general scheme. But the general scheme shows that these arrangements have been made in advance. The airlines formed a LLC that engaged in a throughput and deficiency agreement with the terminal that requires them to put the product that comes into Tampa onto the CFPL pipeline. Every month, Aircraft Service submits a nomination to the pipeline detailing what's going to come in that month and what will go over the pipeline. There's simply no question that the arrangements have been made. The product is going to come into Tampa. It's going to go over the Orlando pipeline. It's going to go in the amounts that were ordered. And you can just see this by the fact that this is what happens. Every month, the product comes in and it moves through just as it's intended. There's no sense in which something else happens. So to argue as FERC did that the arrangements haven't been made simply because there was no nomination to the pipeline that said, I'm having 100 barrels come in off vessel A and I want it to go on the pipeline on Thursday. That's something that's not practical to do commercially. It's not something that's been done. And it's not something that happened in cases like Sabine or Carson, where product came to the terminal and it was stored there until a vessel came that could take it away. That's a natural feature of the commercial transportation. And the Supreme Court precedent is clear that you're not supposed to let these practicalities obscure the fact that there's an overall intent to move product through the terminal rather than to keep it at the terminal for some distinct purpose other than moving it through to the final destination.
Judge Silberman, Judge Rao, do you have further questions?
No, boss.
No.
All right. Thank you, Mr. Field. We'll give you some time on rebuttal.
Thank you.
I believe next we are to hear from Ms. Ferry on behalf of the Perry, on behalf of the commission.
May it please the court, Lona Perry for the commission. I would like to address the Northville factors that were under discussion at the end of the petitioner's argument. And I would like to point out the commission's findings based on substantial evidence that each of these factors were in fact met in this case. To begin with the first factor is at the time of shipment, there is no specific order being filled for a specific quantity to be moved beyond terminal storage to the final destination. As was recognized previously, that means sent to Orlando in this case. And it is correct, first of all, that the commission, the administrative law judge and the commission found that these nominations that the petitioner was discussing were estimates. But in addition to that, there is a reason why the petitioner was referring you only to Delta's nominations. In the first place, the administrative law judge found that 3 of the airlines who put nominations to their marine suppliers only identify Tampa as the delivery point. And that's in the initial decision at paragraph 191. So 3 of the airlines don't even specify any point of delivery past Tampa. So there can't be, by definition, any specific order for delivery past Tampa with those airlines. The other 2 airlines, Delta, which he was just discussing, and Southwest, do in their nominations specify points beyond the terminal storage. But the administrative law judge found with respect to that, both of those shippers are shippers on, both of those airlines purchase from Valero. And Valero loads its ships in foreign ports prior to receiving the nominations from the airlines. And you can find this at paragraph 178 of the initial decision. And because of that, there is no way that the marine supplier is loading its ships based on any specific order that is coming from either Delta or Southwest with regard to those amounts.
But Ms. Perry, when Delta or Southwest make that nomination, they know that the fuel will be traveling, interstate or internationally in that case. I mean, so they're aware of that when they make that nomination.
No, Your Honor, it needs to be at the time of shipment, there is a specific order to the shipper. The marine supplier is the shipper in this instance with regard to the first element. So it is not a question of whether the airlines know that ultimately this fuel is going to go to the regional airports or to Orlando. The question is, what does the marine shipper know? And the marine shipper does not know, because the vessel is loaded before the nominations are received, where any of this fuel is ultimately going to be delivered. And so that's why there is no satisfaction of the first Northville factor. The second Northville factor, the character of the storage, the commission found in the first instance that this storage in Tampa, like that in Northville itself, and like that in Interstate Energy, was used for the purpose of inventory and storage. Specifically, if you look at paragraph 159 of the commission's order, the commission finds and affirms the administrative law judge's finding that there was direct evidence of airlines' intent to follow the recommended inventory by aircraft services, which was to maintain a 20-day fuel supply that was split between Tampa and Orlando. And that was the purpose for the delay. The paragraph 146 of the order, the delay at Tampa was attributable to the desire of the airlines to maintain inventory at Tampa, not for continuous transportation. In addition to that, the commission also found and affirmed the administrative law judge's findings that in addition to the facts of Northville and Interstate, in which the using it for inventory was sufficient for purposes of interrupting the continuity of travel, there are additional facts here which further support the finding that the continuity of travel was interrupted. That includes that it was a distribution point, which is there was distribution between the regional airports and Orlando once the fuel is received in Tampa. Furthermore, there's distribution among the airlines because shipments from Chevron are not allocated among the airlines until they are delivered in Tampa, and aircraft services makes that allocation. And in addition to that, the airlines treat the fuel that is received in Tampa as being a fungible pool that can be shared among the airlines as necessary. Specifically, the administrative law judge and the commission pointed to negative inventory, where airlines are permitted to borrow from the accounts of other airlines if they are running short of fuel supply at the end of the month. And the commission found that this was actually a common occurrence. And if you look at the initial decision at paragraph 285, they list how often 3 of the airlines use this frequently, and they list how many days during the relevant time period that happened.
Ms. Perry, can I ask you maybe a little bit different question that I was trying to get at the bottom of is if FERC finds that there has been an interstate shipment, is FERC required under the ICA to set just and reasonable rates? I mean, I guess another way of putting that is FERC's jurisdiction mandatory for interstate shipments, or is there any discretion for FERC to decline jurisdiction to set rates?
I don't know that there's a ground on which the commission could decline jurisdiction if it were a jurisdictional pipeline.
Because the ICA is written in different terms from FERC's other statutes involving the setting of rates, and so I don't know. I couldn't figure out the precise answer to that. So I was wondering what the agency's position was on whether they have discretion to decline jurisdiction under the ICA.
I don't know of a commission answer to that, Your Honor, and certainly it didn't come up in this case because they found that the pipeline at issue was not jurisdictional. So I can't tell you what the commission's position on that would be, whether it would feel compelled to exercise jurisdiction or not. But because it found that jurisdiction did not exist in this case, it didn't come up.
But it would bolster the agency's argument, right? That even if there was sort of a close case, that they have discretion not to exercise jurisdiction, right? So if they have discretion, then, they get a little more leeway maybe in close cases.
I understand your point, Your Honor. I don't believe that the commission made any findings regarding its jurisdictional discretion in this case. They found that the Northville factors clearly all pointed towards there being no jurisdiction over this pipeline transportation, and therefore it was not an issue. They did not regard it as being, at the end of the day,
No, I understand that. I just think it's a legal question that it seems the agency should have an answer to. But I guess if it doesn't, that's fine.
What do you think about counsel's argument that he didn't have a chance to get to, that Gutman recognized that the Norville factors were not adequate? That's the way he put it. What's your response to that? And therefore, his main argument is that the FERC should understand the economic realities, that the only way this fuel can be shipped to Tampa is the method they're using. I mean, that can be shipped to Orlando is the method they're using.
Your Honor, Gutman did not, under any circumstances, disavow the Northville factors. What Gutman found, and you can see that the commission talked about this in note 253 of its order, what the commission found in Gutman was that the Northville factors, which they entirely recognized were commission precedent, did not apply in that case because interstate transportation in that case was found to exist because there was no non-operational storage used
It was just pipeline to pipeline.
It was just pipeline to pipeline, Your Honor. And they were trying to say that the junction between the two pipelines, the Chelsea Junction, that was a point of interruption that was sufficient to break the continuity. And the commission said that's not a break in the continuity of transportation. And therefore, the Northville factors don't apply. The Northville factors only apply where there is a break, where there is an interruption in the shipment. And you apply the Northville factors to determine what the nature of that interruption is and whether it interrupts the continuity of transportation.
The key argument that petitioner raises in this case is the economic realities require the system that is used, and that should be taken into account.
Your Honor, the fact that they organized, as the commission found, you would expect them to organize their business in the most efficient way for purposes of supplying themselves with jet fuel. But the point is, the way they have organized this transportation, it leads to an interruption in the continuity of transportation that is not for purposes of onward transportation, which is the difference between Carson Petroleum and Sabine, where the Supreme Court specifically held that the delay in transportation there was only for purposes of onward transportation. In this case, on the other hand, the commission specifically affirms the administrative law judge's determination, and the commission's finding is at paragraph 162 of its order, that specifically affirmed the ALJ's determination that the petitioners failed to show that they were moving the oil from, the jet fuel, from Tampa to Orlando as expeditiously as possible. They put in a supply chain model that purported to show that, and the administrative law judge and the commission both rejected that model and found that they had failed to make a showing that it was going as expeditiously as possible. To the contrary, it was being held in Tampa for purposes other than its onward transportation to the Orlando airport. So in other words, the commission's finding was that the existence of the interruption, that everybody is planning their deliveries as efficiently as possible. And in Atlantic Coast, the deliveries were planned there presumably as efficiently as possible by Standard Oil, but the fact remained that the way their business was conducted, it was most efficient for them to hold the oil in storage until for later delivery to their bulk stations, as opposed to sending it out by immediate continuity of transportation. As the Atlantic Coast described it, it was being held there for convenient distribution instead of being sent through the storage onward to the bulk stations by immediate continuity of transportation. And that's the distinction, the fact that they organize it as efficiently as possible. Some efficient organizations result in there being a break in the continuity of transportation. And it's the continuous transportation, not the efficient organization, that is the jurisdictional issue.
Seeing as you're over your time, Judge Silberman, I don't want to preterm this if you had further questions, or Judge Rao.
No, I don't have any questions.
All right.
Thank you.
Thank you, Ms. Perry. I believe next we have, on behalf of the interveners, Ms. Hoff.
Good morning. May it please the court. My name is Amy Hoff. I'm appearing this morning on behalf of the interveners in support of FERC. Your Honors, I believe that the fundamental problem with the petitioner's argument is relatively simple. What the petitioners advocate is a complete departure from Supreme Court and Commission precedent. In order to adopt the jurisdictional test that the petitioners advocate, FERC would have had to reject the Supreme Court's decision in Atlantic and the FERC's own decision in Northville Dock as wrongly decided. Why? Because the test that the petitioners advocate would require FERC to focus, as Mr. Field indicated, solely on the undisputed facts that jet fuel starts at locations outside of Florida and ends up at locations within the state of Florida at the inland airports, and that the airlines want and need this to happen in order to operate their aircraft. In other words, according to the petitioners, these facts alone are sufficient to require a finding that transportation on Central Florida is an interstate commerce. But Your Honor, this is not the test. Right, Mr. Field spoke earlier of whether or not there's a fixed and persisting intent to move through storage to the ultimate destination, but that's not entirely accurate. The test is whether there is a fixed and persisting intent to make a single continuous movement in interstate commerce. Not whether there's an intent to ultimately get to the destination, but again, whether you do that in a single continuous movement.
It's rather confusing, isn't it, counsel, to use the word intent? The real question is whether there's a continuous movement or not.
Yes, Your Honor, there is.
These are objective factors.
Yes, Your Honor. That is right. If you look back at all of the Supreme Court precedent, Atlantic, right, all of the earlier cases as well, and then go on to the Commission's decision in Northville Dock, right, and Interstate Energy, all of those cases look, right, they do evaluate whether or not the shipper has a fixed and persisting intent to make the single continuous movement in interstate commerce. But in making that determination, the court always looks at the objective factors, right? All of the details and all of the facts surrounding transportation, which the court and the commission have referred to as the indicia or the manifestations of intent. So again, the court and the commission, they don't just look at where the product starts and where it ends up and did the shipper intend for it to get there, but they look specifically at how it got there and what happened at any intermediate port or point of storage. And then they look at, again, whether that was a single continuous movement or whether, for example, there was a break. Your Honor, I see that I'm out of time.
Did you notice that you filed the only brief with the use of acronyms created for this case that are not commonly used, contrary to our wishes?
No, Your Honor, I was not aware that was contrary to your wishes, and we do apologize for that.
In our rules.
Thank you, Your Honor. I will say that this was a case in which there was a heavy use of acronyms from beginning to end, and so we apologize and simply intended to add clarity.
It doesn't add clarity for people who are not specialists in the industry, and administrative law cases are important for all administrative lawyers. So in any event, we hate acronyms that are made up for cases other than acronyms like FERC.
Thank you, Your Honor. I see that I'm out of time. Are there other additional questions?
Judge Rao? Judge Silberman?
No, sir.
Right. Thank you, Ms. Hoff.
Thank you, Your Honor.
Field, I know you were out of time, but we will give you 2 minutes for rebuttal.
Thank you, Your Honor. I'd like to first start off with addressing the question of whether a temporary pause in transportation can dictate the jurisdiction. FERC itself recognized in the Texaco case that storage by itself is not an indicia of an intrastate movement. The Settle case from the Supreme Court says that a pause in transportation does not break the continuity of transportation where there's a persisting intention of the shipper, which was carried out. That's at page 74 of that case. The ICC and the Railroad Commission of Texas versus Oil Field Haulers Association says that if the halt in movement is a convenient intermediate step in the process of getting the goods to the final destination, they remain in commerce until the final destination is reached. Similarly, in the Iron and Steel Articles case, which we brought up on our brief on the exceptions, but FERC never addressed in its order. While there must be continuity of movement before the transportation as part of foreign commerce, such continuity is not interrupted by a temporary pause in the carriage of goods. The fact that this product stops at Tampa is not decisive in this case. The question is whether the product was ordered for the purpose of moving through Tampa to Orlando, and the undisputed evidence in this record clearly indicates that it was.
Excuse me, counsel, may I ask a question? What is the amount of deference we owe to FERC's determination in this case?
Sure. In this case, you do not owe deference to FERC because FERC has made a legal error, not just an error of the facts. We are not contesting, for the most part, the facts that they found on the record, but where the agency's decision is not based on its exercise of judgment, but on an erroneous view of the law, no deference is owed to the agency.
And what's the erroneous view of the law? Oh, actually, we do give deference to agencies' determination of legal questions as well as factual questions. You're aware of that, aren't you? If it's a legal determination, we review it under whether it's arbitrary and capricious. Unless, isn't that, and if it's a statutory interpretation, we give deference to that too. But it's really not a statutory interpretation question. It's an application of the jurisdictional issue. Wouldn't we give deference to that? What legal error, in your judgment, we should not give deference to?
Legal error that you should not give deference to is the decision to exclude evidence of affirmative shipper intent that did not fit neatly within the Northville criteria, and that was based on the recurring pattern of shipments rather than a single shipment at one point in time. The recent Gutman case makes clear that where there's evidence of intention that a shipment will move forward, the application of the Northville criteria is not necessary. FERC has not specifically applied the Northville criteria in a number of cases. We discussed those at pages 48 through 51 of our brief. And the question is always, what is the intent behind the movement overall? Here we have product being ordered specifically to go to an inland destination. And when that's the case, that's enough to justify a finding of jurisdiction. And it was inappropriate legally for FERC to reject evidence such as the request for proposals that the airlines put out that specifically identify that they are soliciting product to move to the airports. It was inappropriate for FERC not to countenance evidence of the throughput and deficiency agreement that the airlines have set up that requires them to move product through Tampa to the terminal. And it was inappropriate to exclude the evidence of the model that the airline's expert put on, which FERC specifically excluded because it did not go to the Northville criteria, not because it thought that the model was wrong. So those are legal errors that where FERC applied too narrow of an interpretation of the task at hand. And for those reasons, this court should vacate FERC's order.
Thank you, counsel. Further questions, Judge Rao, Judge Silberman?
No.
All right,
no.
Thank you. We will take the case under advisement.
You out of there?
Yeah, we can leave. You want to leave?
I don't care. You can do whatever you want. Just so we don't hear us. I don't.
Hello? right, Judge Rao and Judge Silberman, are you ready to proceed?
Yes.
Yes.
All right, please call the next case.
Case number 19-7105, Larry Elliott Klayman, appellant, versus Judicial Watch, Inc. et al. Mr. Zimkowitz for the appellant, Mr. Driscoll for the appellees.
May it please the court, my name is J.P. Simkowitz, and I have the honor of representing Larry Klayman, who's the appellant in this matter. I reserve 3 minutes for rebuttal. The litigation in this case involves Mr. Klayman's voluntary departure from Judicial Watch, a public interest nonprofit that he founded. The case involved a complaint and a counterclaim alleging trademark violations, defamation, and a breach of contract with regard to Mr. Klayman's voluntary departure from Judicial Watch pursuant to a binding written severance agreement. After hearing evidence at trial, the jury returned a verdict on all claims and counterclaims against Mr. Klayman and returned a huge $2.8 million damage award. This will bankrupt Mr. Klayman and his family. Our brief in reply extensively discusses the issues on appeal, and we direct your honors to the briefs for points that we unfortunately have no time to discuss today, if that's the case.
You might want to start with whether we have jurisdiction to hear this appeal.
That's on March 14th, 2018, the jury verdict was entered in the case. On March 15th, 2018, the trial court entered a final judgment order. On April 12th, 2008, the trial court vacated the final judgment order. The parties engaged in some post-judgment briefing, and a new final judgment order was entered on March 18th, 2019. Mr. Klayman, on April 12th, 2019, filed a timely Rule 60 motion. And then that motion was decided in Judicial Watch's favor on August 7th, 2019, when the court denied Mr. Klayman's Rule 60 motion. On September 6th, 2019, Mr. Klayman filed his notice of appeal, which was timely. And
let me just cut to the chase here. When the district court entered judgment on the jury verdicts, Mr. Klayman filed a motion essentially to set aside those judgments so that he would have 60 days after the transcripts had been prepared to file his Rule 59 motion, right?
He filed the motions, Your Honor, yes.
Under our case law, American Security, it's cited by you and the other side, that motion should be construed as a Rule 60B motion itself, right? Wouldn't you agree that's what we held there, that a motion of this nature is essentially seeking relief from judgment and should be construed as a Rule 60B motion?
Well, I don't agree, Your Honor. I think that what happened here was that the order was vacated, and the vacation of that
it was vacated not sua sponte, it was vacated in response to a motion filed by Mr. Klayman.
That might be the
question is that motion under our case law is properly characterized as a Rule 60B motion, right?
No, I don't think that's correct, Your Honor. I believe that the evidence that the trial court vacated the judgment for any reason, the fact that the judgment was vacated allowed Mr. Klayman a second, quote, bite of the apple. And that's what happened when...
maybe I'm not being clear. Mr. Klayman filed a motion. And that motion, according to American Security, is properly characterized as a Rule 60B motion, right?
I'm not sure, Your Honor. I think that the answer is that because it was vacated, it became a nothing. There was nothing to appeal at that point. He couldn't file notice of appeal in April 2018. There was nothing to appeal. It was only when the new judgment was entered that in March of 2019 that Mr. Klayman could had anything to file, and that's when he filed the Rule 60 motion in April 2019. When that was decided in August 2019, then against him, then and only then did Mr. Klayman
American Security
to file
American Security also held that it doesn't matter whether you file a Rule 59 motion before or after judgment. It still counts as a Rule 59 motion, right?
I don't concede that, Your Honor. I think that the key distinction is that the orders were vacated, and that Mr. Klayman did file some post-judgment motions, but when the new final judgment order was entered, that gave him the ability to file the Rule 60, and upon the denial of that Rule 60 in August of 2019, then and only then could he file the notice of appeal, which he filed within the 30 days of entry of the final judgment order in August of 2019. I think that's the key distinction.
So I'm aware of at least 6 different circuits that have held that you cannot file in reported decisions, that you cannot toll the time period under Rule 4 twice with successive motions under Rule 9 and Rule 60.
But our argument is that
I understand what your argument is. I'm asking you whether you are aware of any authority to the contrary with respect to that proposition.
I'm not aware of any the way you phrase it, I'm not aware of anything, but I think the facts are different there. I think that the court vacated that judgment order, and it's the vacation.
But okay, so you're not aware of any authority to the contrary that you can't toll the time period twice. So what I'm saying to you is, if we were to construe Mr. Klayman's first motion as a Rule 60B motion that was successful and resulted in the court setting aside the verdicts so that he would have more time to file his Rule 59 motion, and then that motion was filed and it was denied, and then he files another motion after that, and we were to construe that third motion as a second bite at the apple to toll the time period, you are aware of no authority that says that you can toll the time period twice in that fashion, if we were to construe that as what has happened.
Your Honor, I'm not aware of any authority. However, I don't think that that's what happened here. What happened here is that there was a second final, the first final judgment order was vacated. That meant there's nothing to appeal. There's nothing going on. It's only when the second final judgment order was entered in August of 2019 that Mr. Klayman had the ability to file the notice of appeal, and that's, I think, the critical fact that the other cases and the other authorities that may or may not be out there differ from this case.
Forgive me. Let me ask a question. I'm perhaps a little confused. What is the cases that my colleague refers to? Are they before or after when 4A6 was entered into the rules? Which for relief under Rule 60, if the motion is filed no later than 28 days after the judgment is entered. What was the date on which that was put in, and how does that relate to the cases that my colleague refers to?
I'm not sure of the date that went into effect, Your Honor, but again, that it
may be important for your case.
Rule 4, I know, was amended in 1993 to specifically include Rule 60 motions. And that's in Rule 4's advisory committee notations to the 1993 and 1998 amendments. But
right. The cases that my colleague refers to before those, American Security is before that, isn't it?
Yeah, American Security is before that.
Yeah, that's
yes. It's that was a 1982 case, Your Honor. Yes,
that's my memory too.
So the ability for Mr. Klayman to file that Rule 60 motion that came in that he filed on he filed in April of 2019. That told us time to file the notice of appeal. The order was denied on August 7th, 2019, and he filed the notice of appeal on September 6th. So we believe that his appeal was timely, and in addition to timely, that this honorable court has jurisdiction. Moving to, if I may, moving to our arguments on, as I see that I'm out of my 7 minutes, Judicial Watch provided a constant drumbeat of false claims to the trial court that Klayman had an affair and sexually harassed a married office manager that worked for Judicial Watch, and she had small children at the time, that he assaulted his estranged ex-wife and called her vulgar names, such as a piece of shit, a dumbass, ugly, stupid, and a bitch, and 3, that his departure from Judicial Watch was forced. These false statements resulted in significant prejudice to Klayman and resulted in a huge verdict against him. Judicial Watch's appeal is defeated by the uncontroverted truth that Klayman did not have an affair with or sexually harass the office manager, did not beat his wife or call her vulgar names, and that his departure was voluntary. The party severance agreement clearly states that the departure shall be treated for all purposes as a voluntary resignation and that he stepped down to pursue other endeavors. The severance agreement further provided that Judicial Watch issue a press release that praised Klayman, stating that Larry conceived, founded, and helped build Judicial Watch to the organization it is today, and we will miss his day-to-day involvement. Larry leaves us well-positioned to continue our important work. And it also stated that Larry was the creator and founder of Judicial Watch and helped to build it to be a stable, successful, and widely respected organization, and we thank him for his service. Moreover, the severance agreement stated that the parties agreed that they will limit any statements to third parties regarding Klayman's leaving Judicial Watch to be consistent with the press release and statements contained in this paragraph.
Mr. Sienkiewicz,
yes.
So, I mean, these evidentiary questions we review under the abuse of discretion standard. Isn't that correct?
That's correct.
Right. So how do you overcome that deferential standard?
Well, we believe that not only was it abuse of discretion, but it was clear error because the statements that were made were so prejudicial that under Rule 401 and 402, in addition to being irrelevant to the claims at issue, which were the trademark violation, breach of contract, and defamation, that they were smears that were so bad that 403 prevents the admission of these false smears, since the probative value of admission is substantially outweighed by the danger of unfair prejudice, confusion of the issues, and the potential to mislead the jury. And that's what happened here. The jury heard evidence that Mr. Klayman was this horrible guy that was a sexual harasser. He had an affair with a married office manager, that he assaulted his wife and used really bad names, and that he left for a reason other than to run for the Senate. And 403 clearly indicates that this evidence should have been excluded from the jury, because it, in addition to being irrelevant under 401 and 402, under 403, it was the danger of prejudice. The danger of the admission is that it was substantially outweighed by a danger of unfair prejudice, confusion of the issues, and the potential to mislead the jury. And the admission of such false, irrelevant, and extremely prejudicial and incendiary smears obviously provoked the jury into finding against Mr. Klayman on emotional grounds that were different than the objective proof required to support the causes of action. And the only thing that that this court can do is to rectify this grave errors, to reverse and remand for a new trial. The court made other errors that we stated in our brief, and Your Honor, I can go through them.
We have your brief. Are there further questions from the panel? Judge Rao, Judge Silberman?
I do not have any questions.
No further questions. Thank
All
you.
right, you're out of time, but we'll give you some time on rebuttal.
Thank you.
All right, we'll hear now from Mr. Driscoll for appellees.
Thank you, Your Honor. May it please the court, my name is Rich Driscoll. I'm here on behalf of the appellees, Judicial Watch Incorporated, and the individual directors, Thomas Fitton, Mr. Christopher Farrell, and Mr. Paul Orphanides. Today, I think the court has focused on a preliminary and dispositive issue that is important to address, which is the lack of jurisdiction that this court has to hear these matters on appeal. Judge Silberman asked an interesting question, which was, what was the date of the decisions in which the court espoused the general rule that a motion for reconsideration filed after a time tolling motion, like a Rule 50 or a Rule 59 motion, does not toll the time period. And the dates of those, the American Security Bank decision is 1982, but following American Security Bank, this general rule has been reiterated and reapplied in 2003, 2005, 2016, and as recent as 2017 in the Dugdale versus Ditech decision.
You're talking about unpublished opinions, are you not?
That's correct, Your Honor. Those are unpublished opinions.
Number one is unpublished. Number two, it does not. None of those opinions consider the actual language of Rule 4 as it is amended. Isn't that correct?
Well, the amendment in Rule 4 in 1993 included a Rule 60 motion as one of the motions that can file, that you can file and toll the time limit. However, the rationale...
Look at the language of that. 4.6 says for relief under Rule 60 if the motion is filed 28 days after the judgment is entered. And then you go and look at Rule 60, and it's grounds for relief from a final judgment, order, or proceeding. So the draftman used the term for relief because it's broader than one directed towards the judgment. It also includes an order. So why doesn't that specifically allow a Rule 60 motion to come in after a 59 has been denied? In this case, the 59 was denied simultaneously with the judgment.
Well, Your Honor, the answer to that question is that the policy that was announced in the American Security Bank decision was that the purpose of tolling is twofold. One, it's designed to give the trial court, an opportunity to correct errors before the parties have to prepare for an appeal, and it's to relieve the parties from the burden of preparing their documents for appeal. Mr.
Excuse me for interrupting, counsel. I agree with the policy. However, the text of the orders does not support the policy.
I understand your point, Your Honor, and that is the argument of the appellant, which is that the final judgment was dismissed, they filed or vacated, they filed their Rule 59 motion, then the final judgment was entered, and they subsequently filed a Rule 60 motion, which is also identified in Rule 4, and therefore they were able to toll the time period going forward.
That's correct. And actually, counsel did not make the argument that I'm suggesting, but it doesn't matter because it's a jurisdictional question.
Well, so, I understand that, Your Honor. But the point that I'm trying to make, I'm sorry.
How do you get around the exact language of 4.6, A6, and Rule 60.
The way that you avoid that language, Your Honor, is you look at the content of the Rule 50, Rule 59 motion, and the content of the Rule 60B motion, and you can.
And was not the Rule 60B motion different than the Rule 59?
No, it was based on the exact same arguments, and it requested the exact same relief.
My recollection is that the arguments were somewhat different.
Well, there were two additional arguments, but that was because the Rule 60B combined both the Rule 60B motion with a motion to recuse the judge and a motion for sanctions. So it was sort of
put aside the motion for recusal.
Okay.
But what is the actual language of the Rule 60 motion?
The actual motion that was filed?
Yes. Isn't it different than the 59?
One moment, Your Honor.
If it was the same, you would have a better argument, it seems to me, but I recall it being different. Besides the...
When you say, Your Honor, when you say, was the language different, which language are you referring to? The body of the arguments? Or...
No, I'm talking about comparing the Rule 59 motion, which was filed and decided actually simultaneously with the judgment.
Right.
And the Rule 60B motion, which came in later. And then the real question is whether the 60B tolls the time for appeal. And if the 60B motion was exactly the same as the 59 motion, I think you'd have a stronger argument. But if it's different, then the rules look textually against your position.
Well, I'm looking at the 60B motion at the moment, and it appears that based on that it includes the exact same arguments substantively that the Rule 59 motion included, but has only the argument that the order that was issued on March 18, 2009 was driven by a continued extrajudicial animus by the court. And so there's no substantive difference between...
I seem to recall there was.
I'm not going to agree with that.
Okay.
There's another point I would like to make, though, Your Honor, which is that the American Security Bank Court made the point that whether tolling occurs is not relevant. It's not like calling timeouts in a football game. Parties don't have an absolute right to tolling because the tolling has to serve the purposes that are espoused by the court, which is to give the trial court the opportunity to correct mistakes and to relieve the parties from the burden of preparing an appeal while there's still an opportunity for a new trial. Those were all issues that were covered in the original Rule 50, Rule 59 motion, but were not covered and then were reiterated in the Rule 60 motion, which is actually titled as a motion for reconsideration, yet the motion for reconsideration doesn't even articulate any grounds that would normally be utilized for a motion for reconsideration, which would be newly discovered evidence or a clear error of law. None of that is argued in the Rule 60B motion other than the issue of the continued animus of the court. So I understand the court's position on that, but it doesn't meet the policy of the court, and it violates the general rule that you can't file successive motions to toll the time period. And it doesn't matter whether the motion Rule 50 and 59 were filed before or after the judgment was entered. If you look at the relief that's requested in the Rule 50 and the Rule 59 motion, they're requesting relief from the judgment. And they ask for the exact same relief in their Rule 60B motion and also in the appeal here today. There is an issue that I would like to raise with regard to some comments that counsel made. Just to clarify, the record does not in any location indicate that Mr. Klayman was accused of sexual harassment. There is only one statement by Mr. Orfanides' testimony in which he said that as a member of the board of directors and as an officer of the corporation, Mr. Klayman breached his fiduciary duty by engaging in an affair with a subordinate employee and exposed the corporation to the risk of a sexual harassment claim. There has never been an allegation that Mr. Klayman sexually harassed the individual employee. And so that's an inaccuracy.
Excuse me, may I ask a question about the summary judgment
Sure.
decision? One of the grounds, as I recall, the district judge throughout the submission of the other party in this case at summary judgment was the ground that he was producing hearsay evidence. Do you remember that?
Yes, sir. There were two documents that were rejected based on Rule 56E.
But isn't the law at summary judgment that you can get by with hearsay evidence? You can get by with material that wouldn't be accepted as evidence at trial?
You can get by with hearsay evidence as long as it can be converted into admissible evidence. And the two pieces of evidence that are addressed in the brief are one, just a sheet of paper that has an unattributed summary of a statement by one party. There's no explanation as to who said it or what the source is or anything.
But that all could be produced at trial, right?
Well,
in other words, the general principle is hearsay wouldn't, if it doesn't come under one of the exceptions, would not be admitted at trial. But if it's asserted in opposition for a motion to summary judgment, it's legitimate.
No, I don't agree with that, Your Honor. Rule 56E states that it has to be admissible evidence. And so the burden on the party, the proponent of the evidence, is to demonstrate that the evidence is admissible. And the appellant never met that burden. Even on appeal, they don't even attempt to meet that burden. They merely point to the evidence, which still stands as hearsay evidence that cannot be converted into admissible evidence.
Now, of course, it may not matter even if it was a technical error, because it may not have been decisive in the case.
Well, that's certainly true, Your Honor. There is one other issue that was introduced, and I would be remiss if I didn't address it as long as the court would indulge me with about 30 seconds.
Fine.
And that is the testimony regarding the relationship between the spouse and Mr. Klayman. The rationale for introducing that testimony was not to smear Mr. Klayman. It was to demonstrate the falsity of the representations in the advertising campaign to support the element of falsity in the Lanham Act claims and to demonstrate the disparagement under the breach of contract claims. And so that testimony was not peripheral. It was the heart of the dispute. Mr. Klayman was pursuing an advertising campaign that represented himself as superior morally and ethically to the leadership and advocated that he should be returned to Judicial Watch because of this moral and ethical superiority. And the appellees took the position that that was false advertising. Both sides fully presented their cases to the jury. The jury rejected Mr. Klayman's, and here on appeal, that jury verdict should be entitled to the deference that a jury verdict receives, and all inferences should be given to the appellees on this appeal.
Judge Rao, any further questions? Judge Silberman?
No.
All right. Thank you, Mr. Driscoll. Mr. Simkowitz, you were out of time, but we'll give you 2 minutes for rebuttal.
Thank you, Your Honor. Rule 60 has different grounds than Rule 50 or 59. And under Rule 4, small a for large a Roman numeral 6, it allows the filing of the Rule 60 motion. The Rule 60 motion was different here, and that would fall under the number 6. Any other reason?
Explain the differences.
Well, this one on page 4 of document number 587, which is appendix 2386, it said, unfortunately, the court's order of March 18th, 2019 appears to be driven by its continued extrajudicial animus manifesting itself in bias and prejudice against Mr. Klayman, and has caused this court to ignore the facts and law set forth in Mr. Klayman's JNOV motion. As set forth in detail below, this has resulted in, at a minimum, clear error that has severely prejudiced Mr. Klayman that more than satisfies the requirement for reconsideration under the Federal Rules of Civil Procedures, Rule 60.
What were the errors committed in the denial of the 59 motion? And in what way are they different from the 59 motion?
Well, in the 59 motion, there were some that was related to some of the substantive problems with the case. But Mr. Klayman's Rule 60 motion again talks about the bias and prejudice of the judge, which goes under Rule 60 to any other reason that justifies relief. I think that any other reason that justifies relief should be interpreted broadly in this case, because Mr. Klayman is alleging specifically bias and prejudice in the Rule 60.
I saw that, and I understand your point. But wasn't there actually a substantive difference besides bias? He refers to the judge failure to consider evidence. Wasn't that different than the 59 motion?
It may be, Your Honor.
You should be more aware of the case than I am.
If we can file a supplemental brief, to address that.
But there's no supplemental briefing.
The last thing we need is supplemental briefs.
But Your Honor, I believe that there were some distinctions between those two, and moving on to the other comments that I'd like to address on rebuttal. The Orphanides testimony on page 1830 of the transcript, day 6, he said, Mr. Klayman didn't run for the Senate. He left rather than face an internal investigation into whether he misused Judicial Watch's resources, whether he pursued an inappropriate relationship with the Judicial Watch employee, and whether he was engaged in domestic abuse. That's where we get to the sexual harassment.
All right, you're out of time, counsel.
Thank you, Your Honor.
We have your argument.
Thank you.
The case is submitted.
This honorable court is now adjourned until Thursday, November 12th at 9:30 a.m.